Good morning, everybody, to this knowledgeable Sunday morning, which is organized by Samruddha Bharatang and LEXGENUS for us. And today's topic is also really very interesting. The kind of stories which we are looking into the news nowadays. We need to understand what is the Criminal Procedure Codes 1973, and the topics which is we are gonna discuss about it, like FIR, bail, arrest, and remand. And we have to explain all these things. We have a really very knowledgeable person who's into this field more than 18 years.
Sure.
I'm talking about Advocate Ramesh Jadhav. He's a partner with LEXGENUS Home and holds a degree in arts and law from Mumbai University. As I said, 18 plus years experience in handling civil, criminal, family, and consumer matters. And somebody who's really good at registration work like trust, mandal registration, shop act matters, essential commodity acts matters, cooperative code issues, labor law matters, and SRA matters, etc. So such a wonderful pearl has joined once again. Okay. It is a kind of series which is created for us by Samruddha Bharat Sangh and LEXGENUS. Ramesh Jadhav is one of the pearl in that, trust me. Okay. So Ramesh, we would be interested if you could start the session and help us the details of FIR, bail, arrest, and remands. Yeah. I will request Ramesh to please talk about it.
Yeah. Yes, definitely. Good morning, everybody.
Good morning.
Now, today we are, good morning, good morning. Today we are discussing one important, that is the Code of Criminal Procedure Code. That is the important act. That is the important act in our judicial procedures. The Code of Criminal Procedure 1973 CRPC. The Code of Criminal Procedure CRPC is the main legislation on procedure for administration of substantive criminal law in India. It was enacted in 1973 and came into force on 1st April 1974. It provides the machinery for the investigation of crime, apprehensions of suspected criminals, collection of evidence, determination of guilt or innocence of the accused person, and the determination of punishment of the guilt. Additionally, it also deals with the public nuisance, prevention of offense, and maintenance of wives, children, and parents. At present, the Act contains 484 sections, 2 schedules, and 56 forms. The sections are divided into 37 chapters in CRPC. Today, we are not discussing entire CRPC, but few points we are discussing here. First, we will go through with the FIR. FIR and investigation by the police. In CRPC, there is a chapter 12 inserted in CRPC that's given lots of information about the FIR and other informations. Now, first we see what is the FIR. The first information reaching the police station about the commission of the crime is called the first information report, which is popularly known as FIR. The FIR is the initial point of criminal investigation by the authorized agency, which may ultimately culminated into prosecutions and trial of the accused. FIR is immense value and relevance in the process of investigation and prosecutions. The first report contained the information about commission of a cognizable offense. Then section 154(1) CRPC say, explain as a FIR. Every information relating to the commission of cognizable offense, it given orally to the officer in charge of police station shall be reduced to writing by him or under his directions and be read over to the informant. And even such information, whether given in writing or reduced to writing, as approach said, shall be signed by a person giving it, and the substance thereof shall be entered in a book kept by such officer in such form as the state government may prescribe in this behalf. It is also well settled even by the case laws as whether above section refer to FIR or not. As a such a criminal procedure code do not mention FIR at all. Then we can draw important characteristics required of a FIR. That is R as under that the information should be in point of time. It should be an information definite and reasonable and not merely rumor or village gossip of hearsay of an indefinite variety. It must have given to the officer in charge of police station. It should relate to commission of cognizable offense only. It should the information which set the police on their investigation in particular case. It should be given in writing. It should have been read over to the person who made it and should be signed by such person. It should be entered in a book kept for the purpose. In these characteristics, the first 5 points are substantive in nature and the other 3 points are concerning the procedure. Any information as to the commission of an offense may be treated by the police in the court of law to be a privileged information under section 125 of Evidence Act. And any statement to the police after recording of FIR is made, if not signed under section 162(1) CRPC, then it is not admissible in evidence according to section 161 and 162 of CRPC, except for specified purpose of contradiction as explained in these sections. Now, to understand the meaning and implications of FIR, one should know the definition of certain terms as available in CRPC. Then what are the definition that has been explained that we have to see? The first, complaint. What is a complaint? Any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. Then what is the investigation? Includes all the proceeding under this code for the collection of evidence conducted by a police officer or by any person other than magistrate who is authorized by a magistrate in this behalf. Then what is the offense? Any act or omission made punishable by any law for the time being in force and includes any act in respect of which a complaint may be made under section 20 of the Cattle Trespass Act 1871. The offense definition has been given only in Cattle Trespass Act, not in CRPC. Then what is a cognizable offense? A police officer may, in accordance with first schedule, arrest without warrant. That is cognizable offense. And then what is the non-cognizable offense? Police officer has no authority to arrest without warrant. That is known as NCs. Then we can see the relevancy of FIR and register of FIRs. Then first, then telephone message and FIR. What is the relevancy between the telephone message and FIR? We cannot register FIR as a telephonic message. That is a simple. But you can inform to the police station about the commission of an offense, and then after station officer will visit the spot and initiate the investigation and he found genuineness, then that the police officer reduce the information into the writing and obtain the signature of the informant and include a gist of that information in the diary. For that, the Guwahati High Court in Jitendra Chandra Sahib versus State of Tripura observed this process as a valid recording of FIR. Then information from an onlooker and FIR. What is the relevancy in that? It is not necessary that every time a victim or injured person alone should give information to the police. First information can be given by any person when a victim in a criminal incident is seriously injured and not in position to speak. then an outlooker also can give the information to the police about the crime as he perceived. FIR need not narrate each and everything detail about the incidents of crime. It is enough if it contains the prima facie information about it. It should reflect the rudiment of the prosecution story to make it a useful FIR. Then FRI is not an encyclopedia. The Gujarat High Court observed in one case, that is the Joda Koda Rachari versus State. In that case, Gujarat High Court explained that FRI is not an encyclopedia. The Gujarat High Court rejected the plea that the FIR was not recorded by a person who saw the incidents because the FIR did not contain the information that the deceased was killed by the bullet released from the gun of the accused. The court observed that the FIR is not the encyclopedia of the crime occurred. It does not matter if FIR did not contain the information that the accused reloaded his gun before committing the murder. Held in Punjab and Haryana High Courts in Ravi Narayan versus State and Naurangilal versus State of UP, it was held that when FIR contained the information as to who attacked and who fled the scene, nothing more was required. Then is FIR as evidence? That is a question mark. Now, FIR is not a substantive piece of evidence. It is just the earlier communication of information about the commission of a crime. The informant wants the prosecution of the accused for committing an offense. His main motive is to set criminal law in motion. That is the important thing. However, from the point of view of investigation officer, the FIR form based of their further investigation, their objective is to secure more information about the crime and do all the trace the accused and book him. Being the first information, it has some legal value and importance in the process of establishing the guilt. The FIR can be used as a previous statement of the informant, and when the informant in produced before the court, that FIR can be corroborated or contradicted. If the contents of FIR are corroborated, then the guilt can be proved. If contradicted, it cannot be used to contradict the statement of other witness. Now, the Section 157 of Evidence Act says that deals with the process of corroborating the FIR as a previous statement. While Section 147 of the Act deals with the value of contradict FIR, in several judgments, the law is settled that the information report is not a substantive evidence. In Majidar Rahman versus State of Assam, in that case, it was held that FIR is used only for the purpose of corroborating or contradictions of informant. Then FIR credibility and importance improves if it is given immediately after commission of crime without losing any time. Then there will be no possibility of embroidery, exaggerations, and anybody else intermediate with it. Section 157 Evidence Act says former statement of witness may be proved to corroborate later testimony as to same fact. In order to corroborate the testimony of witness, any former statement made by such witness relating to the same facts at or about the time when the fact took place, or before any authority legally competent to investigate the fact may be proved. Then what is impact of delay of FIR? If FIR is not filed within a time, then the object of insisting upon prompt lodging of the report to the police in respect of commission of an offense is to obtain early information regarding the circumstances in which the crime was committed, the name of the actual culprit and the party played by them, as well as the name of the eyewitnesses present at the scene of the occurrence. In Ram Dattu versus State of HP, in court observed that delay in lodging the first information report quite often results in embellishment, which is a creature of afterthought. On account of delay, the report not only lost the benefit of the advantage of spontaneously, but also the danger creep in of the introduction of colored version. exaggerated account of concocted story as a result of deliberation and consultation. It is therefore essential that the delay in lodging of the first information report should be satisfactorily explained. There is one example. In one rape case, delay in filing FIR in rape case can be understood as a woman generally hesitate to come out open with the complaint due to fear of social stigma and the prestige of the family. Thus, the Supreme Court held that delay in filing of FIR in a rape case would not vitiate of FIR, that is in Harpal Singh versus State of HP. In that case, court observed that responsibility of the police about the FIR. What is the relation police and FIR? Then what is the responsibility has been explained there. The police officer has no power to refuse to record the information as the FIR. He is under an obligation to receive and record the FIR and initiate investigation. In state of Andhra Pradesh versus Unnati Ramula's case, court observed that the police cannot refuse to record the FIR on the pretext that the place of offense was not within the local limit of their police station. Such a refusal could be considered irresponsible as they have a duty to record it and forward to the concerned police station. Then FIR and power of police. The police has the ultimate power to investigate based on the information reaches provided that the complaint crime is cognizable one. If the information did not disclose any occurrence of the cognizable offense, the police has no power to initiate investigation. If the investigation and malicious and in the absence, the disclosure of the cognizable offense, it will lead to abuse of criminal process. In case the charge sheet also failed to disclose any cognizable offense, the prosecution can be struck off under section 482 of CRPC. If the investigation officer has malicious initiated the investigation, even though the information did not disclose the occurrence of cognizable offense, the High Court has the power to quash the FIR and stay the investigation under Article 226 of Constitution. Then FIR information should be authentic. The information on which a police officer is expected to act must be authentic. In other words, the information must be capable of being traced to a specified individual who would take the responsibility of the same, so that should the information subsequently turn out to be false, the informants could be proceeds again. Unauthenticated information would be in excess of the police officer's duty. Then the information must be sufficiently defined and clear enough to suspect that a cognizable offense has been committed. In other words, it will not be sufficient if the information is not clear enough to reasonably exclude the possibility of an accident. But what is required is a responsible ground to believe. Is reasonable ground to believe? The expression has reason to suspecting, section 157 1 CRPC said, is a pointer, but vague information cannot be treated as affording a reasonable ground for suspicion. FIR hearsay. The information may be merely hearsay provided the person in possession of the hearsay is required to subscribe his signature to it and mention the source of his information so that the information may not amount to irresponsible rumor. The FIR and conspiracy cases. In these conspiracy cases arising from shadow, beginning the investigation must be held to have started from the moment when the police officer formed their opinion that there are ground for investigation, the crime, thus first the interest, then suspicions, and finally hardening in ground for investigation the crime. Then rape case and FIR. Delay in filing FIR in a rape case can be understood as a woman generally hesitate to come out open with the complaint due to fear of social stigma and the prestige of the family. Thus, the Supreme Court held that delay in filing of FIR in rape case would not vitiate the validity of FIR. Harpal Singh versus State of HP and Panchu Parida versus State of Orissa. Court held that rural woman was raped in agricultural field. She reported it to her husband and the elder of the village, who decided that police report should not file till the village committee resolve the issue. However, the elderman of the village could not resolve it and the complaint was lodged with the police. The court considered the delay in filing of FIR was reasonable. The name of the accused and witness in FIR. In the Emunappa Gulappa Serangapi versus State of Karnataka, in that case, court held that the police failed to include the name of key witnesses in FIR at the beginning stage itself. However, they tried to insert the name of the witness at the later stage. The court held that such an effort at a delay stage would raise the suspicions and the benefit would go to the accused that could be released immediately. The absence of key information in FIR. It is essential that FIR should reflect the key and material information about the incident. Then FIR to be completed before the police investigation. It means that first you have to file FIR, then investigation will start. It cannot be denied that if the FIR were to be recorded after an inquiry into the offense, the temptation would be great to incorporate it in the FIR details and circumstances advantages to the prosecution which might have been lacking in the earliest information about the offense. So it is necessary to register FIR before completing the police investigation. Then material defect in FIR. According to Section 11 Evidence Act, the FIR can be used as a previous statement of the informant to compare, confirm, or contradict the information mentioned in the first information report, and nothing more than that. In case of Kailash Chandra Sahu versus State of Orissa, court held that the absence of the fact, like one accused handing over spare to another accused who drew it into heart of the deceased, it held to be material defect which weakened the credibility of the prosecution plea against the accused. The non-mentioning of the name of the accused in FIR. If it is not mentioning the name of the accused in FIR, it doesn't mean that the FIR is useless. In the case of Kartar Singh versus State of Punjab, in that case, court observed that FIR has recorded at the earliest point of time, but name of some accused were not mentioned in it due to the confusion state of mind of the complainant. As the prosecution could establish the existence of confusion state of affair, the FIR was not invalidated totally. At all depends on the circumstance of criminal act. To decide the credibility and utility of the first information report, mere absence of the name of accused will not render the FIR useless. Then, what is the relation between FIR and police diary? Section 154 laid down the procedure as to how an FIR should be recorded. That it should, is orally given to the officer in charge of police station, be reduced to writing by himself or under his direction and supervision. That it should be read over to the informant. That it should be signed by the person giving it, and substance of the information should be entered in the prescribed diary, that is station diary. That is the important. The first information report should also be entered in the FIR register kept in every police station. Then false FIR, an offense giving a false FIR is also an offense under section 182 and 211 of Indian Penal Code. The objective of section 154 is preventing previously allegations and unnecessary accusation of cognizable offense, and to punish those giving false FIR. Such baseless allegation causes wastage of valuable time and energy of not only the accused but also people in general and the prosecuting machinery. Then one important point is their quashing of FIR. Article 226 of Constitution and Section 482 CRPC, giving the court power to quash the FIR and stop the investigation when FIR was the result of a civil dispute. It can quash. Then power to question the right of the accused. Investigation officer have right and authority to question the witnesses and accused to collect the relevant data for prosecutions and get the deposition from them. According to section 161 of the code, deposition have to be recorded. Such deposition can be used in prosecution. Article 20 3 of the Constitution provide fundamental right to accuse not to be forced to give implementing answer in interrogation. Then right not to reply. The accused has a give. An accused has a right to be silent when confronted with implementing questions under interrogation. Article 20/3 is a shield provided for an accused from being forced to give information which could be used against him. Then we will discuss the police investigations. What is the police investigation? While the police is authorized as of their right and power to go ahead with interrogations and investigation into a reported crime, if it is a cognizable one, investigation into non-cognizable case can be undertaken only under the order of the magistrate. The police has no statutory power to investigate non-cognizable offense according to section 155 2 CRPC. This deals with power of police to investigate non-cognizable offense. No police officer shall investigate a non-cognizable case without the order of magistrate, having power to try such case or commit the same for trial. Under section 156 CRPC and section 36 CRPC, an officer in charge of police station or any higher police officer has the power to investigate a cognizable offense without any order of magistrate. In section 155(1), when information is given to an officer in charge of a police station of a commission within the limit of substation of non-cognizable offense, he shall enter or causes to be entered the substance of the information in a book to be kept by such officer in such form as the state government may prescribe in this way and refer the information to the magistrate. It is the duty of the police officer who received information about the commission of a non-cognizable offense to see whether the offense is committed within the territorial limit of this police station. If it is committed outside his station limit, his duty is to refer the complaint to the police station having the territorial jurisdiction. Then investigation. The police cannot be permitted to investigate into a non-cognizable offense and take shelter under the plea that the want of authority to investigate was just an irregularity. In a case of cognizable offense, the police officer should get the information, reduce the writing. If it is an oral information and get it signed, he should proceed to enter the substance of this information in the general diary. If the police officer finds some basis for the complaint and has reason to suspect the commission of cognizable offense, he should take steps to investigate the offense and apprehend the offender. In the several offense are alleged, it is the duty of the police officer to decide whether each and every offense alleged in the complaint is cognizable or non-cognizable. Even if a single offense is cognizable, the entire case is a cognizable case. There is no mention in a CRPC of any case to be partly cognizable and partly non-cognizable. Where the police investigation, cognizable case involving cognizable, even one is sufficient, and no cognizable offenses in it is considered as a cognizable case only. Hence, the police do not require any order from the magistrate to investigate such case, as held in Valmadi Kutumba Rao versus State of Andhra Pradesh in that case. Then territorial jurisdictions. The Code of Criminal Procedure says that magistrate should be a magistrate having the territorial jurisdiction to try the case or to commit the accused for the trial. A metropolitan magistrate has no power to order investigation into commission of non-cognizable offense in any part of India. He can order such investigation only within the city limit in which he is appointed as a metropolitan magistrate. Section 155 2 CRPC of Section 202 CRPC authorized the magistrate to order the police to investigate into non-cognizable offense. Section 202 is provision of law under which the magistrate receiving a complaint of an offense cognizable or a non-cognizable may order the police to investigate. Then what is the police report? Under section 202 CRPC, an officer investigation with the sanction of magistrate is under the obligation to report to the magistrate from time to time about the progress of the investigation. The report submitted to magistrate by the investigation officer under section 155 CRPC will be considered as a police report as provided under section 173/2 CRPC, and that can be taken cognizance by the magistrate. That what is the prima facie case? Before sanctioning for investigation in non-cognizable offence, the magistrate has to be satisfied about the existence of prima facie case. If not, it will be treated as arbitrary sanction. Then what is the reinvestigation? The accused and complainant has no role to play in the process of securing a sanction for investigation, which will be transaction between the police officer who investigates and the magistrate who has a territorial jurisdiction to try the case. If the court discovers any defects in investigation, the magistrate can order for re-investigation into the complaint. That is HN Risboot versus State of Delhi. In that case, re-investigation has been discussed in detail. Defect in investigation. Then. The lack of permission vitiated the investigation in a non-cognizable case as well as a trial. This defect is non-curable under Section 465 CRPC or on the ground that no prejudice is caused to the accused. In such case, if challan has been sent, it should be struck down. And that Vasudev versus State in Delhi, in that case, defect in investigation has been discussed there. And then false information. Section 182 and Section 211 Indian Penal Code are the provision which deals with the false information to a public officer or a police officer. Then we will see the Section 182 IPC. Where given to any public servant any information which he notes or believed to be false, intending thereby to causes or knowing it to be likely that he will thereby causes such public servant to do or omit anything which such public servant ought not to do or omit, if the true state of fact respecting which such information given were known by him, or to use the lawful power of such public servant to the injury or annoyance or any person, then shall be punished with imprisonment of either discretions for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Then Section 211 IPC. However, with intention to cause injury to any person, institute or causes to be institute any criminal proceeding against that person, or falsely charge any person with having committed offense, knowing that there is no just or lawful ground for such proceeding or charges against that person, shall be punished with imprisonment for of either description for a term which may extend to 2 years, or with fine, or with both. And if such criminal proceeding be instituted on the false charge of an offense punishable with death, imprisonment for life, or imprisonment for 7 years, or upward, shall be punishable with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Then general diary. What is general diary? Section 155(1) CRPC make it mandatory for an officer in charge of a police station to enter the information received in the general diary and the first information register. Failure to do so will entail serious consequences by way of disciplinary action by the department under Section 218 and 219 IPC. Specified that in accordance with circumstances of this case, a refusal by the police officer to enter a report by any person given to him about an offense, or enter a totally different and false report, instead he commit a punishable offense. Then charge sheet. The investigation officer is expected to file a charge sheet only in the case where it appears to him as a result of investigation that the offense has been committed. Section 173(2) of the code contemplated a report regarding as offense. Even if the police has made a negative report against an accused person and show his name in column number 2, thereof such a person can be committed for trial to the court of session by the magistrate. The magistrate has full jurisdiction to differ with the conclusion of the police in its report under Section 173 and direct that the accused person mentioned in column 2 thereof should be summoned and committed to the court of session for trial. That is, and Surat Singh versus State of Punjab, in that case, this issue has been discussed. Then power of court. What power have given to the police? According to the Section 160, a police officer making an investigation may by a written order require the attendance before him of witnesses being within his local limits or adjoining station and acquainted with the circumstances of the case for the purpose of oral examination. The provision, however, provided that a male person under the age of 15 years or a woman shall not be required to attend any place other than the place in which such male person or woman resides. The witness are bound to answer all questions relating to the case put to them by such officer other than question, the answer to which would tend to expose them to a criminal charge or to a penalty or forfeiture. The police officer, however, may reduce into writing any statement made to him in the course of such examination and make a separate record of the statement of each such person as per section 161 of the code. But such statement to the police shall not be required to be signed by the person making them, say in section 162 of CRPC. Then protection to accused. What protection has been given to the accused? Section 161 of the code enable the police to examine the accused during investigation. There is prohibited swept in Article 20/3 of Constitution, which say that no person accused of any offense shall be compelled to be witness against him. This protection is available to the accused in the state of police interrogations also. Section 161 of the code and Article 20/3 of the Constitution substantially cover the same area so far police investigation are concerned. Then right to silence. Article 20/3 provides the right to be silent and bans the self-accusations. While investigation or trial is underway, this protects the accused in regard to other offense pending or imminent, which may deter him from valuable disclosure of incriminating matters. That compel testimony. On the other hand, if there is any mode of pressure, subtle, of crude, mental or physically, direct, indirect, but sufficiently substantial applied by the policeman for obtaining information from an accused, strongly suggestive of guilt, in become compelled testimony, vocative of Article 20/3, a police officer is a person in authority, insisted answer is a form of pressure, especially in the atmosphere of a police station, unless certain safeguards arising during the adhere to. Duress statement meant to the police. Section 161 of the code provides that a police officer making an investigation or any police officer not below such rank as the state government may prescribe may examine any person orally acquainted with the fact and circumstances of the case, and such person shall be bound to answer all questions relating to such case except question the answer to which would tend to expose him to criminal charges or to a penalty or forfeiture. Section 162 of the code explains the utility of such statement as a piece of evidence and lay down the preposition of law. No statement made by any person to a police officer in a course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it. Statement of witness taken in the course of police investigation must not, therefore, by sign, and even if they are signed contrary to express provision of section 162, they do not amount to statement or become admissible as first information. Provision to section 162(1) of code states that when any witness is called for the prosecution in such inquiry or trial whose statement has been reduced into writing, the course of the police inquiry, any part of his statement, if duly proved, may be used by and with the permission of the court by the prosecution to contradict such witness in the manner provided by section 145 of Evidence Act. And when any part of such statement is so used, any part of thereof may also be used in re-examination of such witnesses, but for the purpose only of explaining any matter referred to in his cross-examination. Then protection under section 162 is granted to the accused, and that protection is unnecessary in an proceeding other than an inquiry or trial. For example, in a civil proceeding or in a proceeding under Article 32 of Article 2 to 6 of the Constitution, wherein such statement given to a police officer can be used as a evidence. And Khatri versus State of Bihar, in that case, court observed that. In section 163, no endorsement to be offered. No police officer or other person in authority shall offer or make or cause to be offered or made any such endorsement, threat, or promise as mentioned in section 24 of Evidence Act. But no police officer or other person shall prevent by any cautions or otherwise any person from making in the course of any investigation any statement which he may be deposited to make of his own free will, provides that nothing in this subsection shall affect the provision of section 4 of section 164, which lays down the mandatory provision with regard to the magistrate duty to explain to the confessing accused that he was not bound to make confession and that he does so, it may be used as evidence against him. Then we are turning one interesting part, that is arrest. Understanding arrest, search, and seizure under CRPC. Life and liberty are reveals freedom of our concentrate constitution under Article 21, but it has been repeatedly hindered by the exploitations done by the police, meant to protect us owing to the vast power provided to them by the Code of Criminal Procedure. It is up to the common people to thoroughly understand the concept of arrest, search, and seizure in order to protect themselves from such harassment and injustice by the people in power. Then, what is an arrest? Interestingly, the criminal code, which deals with the aspects of arrest, has not defined the terms arrest, means the definition has not been given. Hence, the general idea is that arrest means a curtailment of a person's liberty for legal purpose. In arrest, a person will not be allowed to move as per his whims and fancies. Legally, arrest means preventing a person from having free movement by applying the authority under law. Arrest is meant from disabling a person from destroying the evidence or threatening the witness from revealing the truth of his crime. Then, whenever a person is arrested, the arrested person is taken into the custody of an authority empowered by law to detain the person. The arrested person is then asked to answer the charge made against him, and he is then detained in order to prevent any further crimes which may be committed. At a time, there is also restraint by the legal authority, but sometimes the person voluntarily submitted to the custody of the person making the arrest. Then there are two types of arrests. There are preliminary two types of arrest. One is that an arrest made in view of a warrant issued by a magistrate, and second, an arrest made without such a warrant but in accordance with some legal provision permitting such as arrest. Then who can arrest and under what circumstances? Then first, a police officer can arrest, a magistrate can arrest, and also private person can arrest. A police officer under section 41 of CRPC may arrest any person without the order of magistrate and warrant under special circumstances mentioned in it. Then a magistrate can also under section 44(1) of the CRPC. Then a private person is also entitled under section 43(1) of CRPC to arrest a person who in his every presence committed a non-bailable offense or who is a proclaimed offender. Then what is the procedure for arrest? Section 46 of CRPC explain the procedure for arrest. An arrest ought to be made by actually touching the person except where he submit to custody by words or action. This section also provides some protection in the matter of the arrest. A woman in ought to be submitted to custody by words only and shall not be touched by the police officer except when the circumstances require so or where a female officer is present. Then also no person has the right to cause the death of the person who has not been accused of an offense punishable with either death or life imprisonment. Then what is the right of the arrested person? And CRPC has given vast power to the people authorized by law to make arrest. However, in order to make sure that such power is not misused, it has also provided people who are arrested with the various right to protect themselves from any harassment. Then right has been discussed under right to be informed. As per section 51, it is the duty of the person making the arrest to inform the arrested person the ground of his arrest. Then right to bail. If a person has been accused of a bailable offense, it is his right to be informed that he is entitled to his right. Then right not to detain for more than 24 hours. As per section 57 of CRPC, a person arrested without a warrant shall not be detained in custody for more than 24 hours. Within 24 hours, the accused shall be produced before the magistrate. Then right to be defended by a legal practitioner. Article 22(1) of the Constitution laid down the fundamental right of the person arrested to consult a legal practitioner of his choice. Further, also is the duty of the court under Section 304 of CRPC to engage a pleader at the expenses of the state for accused if he himself has not sufficient means to engage one. Search and seizure. In the process of investigation, the term search refer to the examination of the investigation or the permission of such suspect in order to process material evidence, and seizure mean to take the possession of that property after the due search has been completed. Search hinders the individual from enjoying his property, but it need to be carried out for legal purpose. Article 95, 19/5 of the Constitution of India also mentioned that the right to hold a property is not absolute, and these rights come with its own set of restrictions. Then some vital point to be remembered requiring these are: the police have the authority to seize the property of the accused even in case of non-cognizable offense. However, there need to be reasonable suspicion behind such seizure, and it has previously been established in the case of in Bethel versus State that the police officer solely is authorized to seize such property and he cannot delegate another individual to do so. Under Section 47 of CRPC, the police officer is free to enter and search the premises. However, this power can only be exercised when the officer is acting under the warrant of arrest. The police officer also has the power to break open the door or window with an aim to free himself or another individual under Section 58 of the Act. The police also has the power to search a person in any place in the territory of India. Then under Section 165(1) of the CRPC, the police may conduct a search within the limit of the station. This section does not cover the case in which search the court issued warrant. During the investigation, the police, after the search, is entitled to seize a few articles. However, the police has to prepare a seizure spot panchanama in compliance with the code, since the individual often put allegation upon the police officer alleging that the article have been falsely planted. Previously, the court has held that the evidence obtained by improper means such illegal search and illegal seizure will not per se inadmissible and dependent on the circumstances of the case. Now, knowing and understanding the due process of arrest, search, and seizure can save a person from harassment and injustice treatment by the very people who are entrusted with the responsibility of ensuring law and order in the society. Now, we are turning to the one important section, that is bail and bail bonds. Section 436 to 450 of CRPC. And what is the bail? Bail is a basically security for appearance of the accused before the court as and when called upon. There is the release of the accused from legal custody, but it purpose that he is in custody. Hence, if his conduct is prejudicial to a fair trial, he forfeit his right and he may be arrested and sent to custody. The bail under CRPC is divided according to the type of offense alleged against the accused. The basic rule of grant or denial of bail may simply be summarized as is a, there are only two kinds of offense under the criminal law. One is a bailable and another is a non-bailable offense. Then we can see here the section 436, that is a inbailable matters. In case of bailable offense, as per section 436 CRPC, bail has to be granted to the accused as it is a matter of right for the accused to demand and be granted bail. The person arrested or detained or appear or brought before the court in a bailable offense shall be released on bail by the court or a police officer. If he is unable to give bail within a week, he can be released on his bond. Bail can be refused in bailable offense if he is brought or appear before the court on subsequent occasion when he failed to comply with the condition of bail bond. Then section 437, when bail may be taken in non-bailable offense. In case of non-bailable offense, as per section 437 CRPC and section 439 CRPC, the grant of refusal of the bail is a matter of discretion of the court. That is the important thing, discretion of the court, which means bail can be granted by the court. Only condition is that it cannot be demanded as a right by the accused. In section 436, that is a right. In 437, that is the discretion of the court. It is depend on court. The section 437 CRPC laid down certain basic criteria for the court while exercising its judicial discretion for granting or refusal of the bail in case of non-bailable offences. Some of the criteria are the nature of offense, past criminal record, the probability of guilt, and carve out exception for minors, women, etc. Section 438 CRPC also laid down the concept of anticipatory bail, where the accused may seek bail if they apprehended arrest, so as to prevent even the otherwise brief incarnations. It must be noted that the grant or refusal of anticipatory bail is also a matter of discretion for the court. The Honorable Supreme Court of India has mentioned several other criteria as factors to be taken into consideration when granting bail in non-bailable offence. To probability of recognition of the offence, possibility of threatening witness, probability of evidence being tampered, the seniority of the accused and his consequences, circle of influence in affecting the investigation if released. When any person arrested or detained without warrant by police officer or appear or brought before a court other than High Court or Court of Session, he may be released on bail except where there are reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment of life, then previously convicted of an offence punishable with death, imprisonment of life, or imprisonment for 7 years or more, or had been previously convicted on 2 or more occasions of the cognizable offence punishable with imprisonment for 3 years or more, but not less than 7 years. In case of person under the age of 16 years or women or sick or infirm can be released on bail. Then section 438. Direction for granting of bail to person apprehending arrest. That is anticipatory bail. That is important also. The High Court or Court of Session may grant anticipatory bail in non-bailable offence, taking into account that is a important things is that nature and gravity of the accusation, antecedent of the applicant, possibility to flee from justice, and when the accusation has been made with the object of injury or humiliating the applicant. And there is a one section is that 167 of 2, that is the default bail has been explained. If prosecution will not file a charge sheet within 60 days or 90 days, then accused got a right to get a bail under section 167 that has been given there. Okay, it's over. I have finished whatever the things I have explained. And in between, I have got some questions that I have to give the answer.
Thank you, Ramesh. So I will ask participants if they have any questions.
Hello, Jadhav sir.
Yes.
Hello.
Please. Yes, please.
How to cancel the non-bailable warrant without producing the accused before the honorable court?
Means how to cancel non-bailable warrant against the accused without present the accused. Okay.
Okay, that is right.
Okay. There is no law stating that the accused should personally remain present for cancellation of warrant. If the lawyer make an application for cancellation of warrant, it need to be considered on merit by the magistrate without insisting the appearance of the applicant of accused. In the Bombay High Court, Justice M.L. Tehelani observed and passed order.
We are listening. We are hearing responses from voices. Lots of positive comments. Feedbacks are coming.
Hello.
Much for your appreciation and the kind of response you people are giving as a team. Thank you very much for that. Today's session we have about the occupational safety, health and working condition code 2020.
Hello.
Advocate Sujit Salkar will be explaining us this thing.
I think
Hello,
somebody is
sir.
playing.
Someone.
Mr. Mane is putting it on.
Okay, I have put him on mute.
Thank you.
Please.
My voice actually.
Okay.
Right.
There is no
Sorry
law
for that.
There is no law stating that the accused should personally remain present for cancellation of warrant. If the lawyer make an application for cancellation of warrant, it need to be considered on merit by the magistrate without insisting the appearance of the applicant or accused. Justice Tehliani, M.L. Tehliani, Bombay High Court, observed and passed the order in Arun Kumar Chaturvedi versus State of Maharashtra. I think the other court, the matter has been conducted by the MM. In that case, court has given directions. There. Hello. Shastri sir.
Hello. I'm listening.
Yeah. Okay, in the High Court, Arun Kumar Chaturvedi versus State of Maharashtra, that has been Justice Tehlani and observed and given a power to cancel a non-bailable warrant against the accused without present the accused.
Thank you.
Yeah.
Good morning, sir.
Yeah. Good morning, sir. Good.
Yeah. What does a person do if a police inspector simply calls them and said, "आप पुलिस स्टेशन आ जाओ, आपके खिलाफ कंप्लेंट फाइल किया है, किसी ने उसके बारे में बात करना है और चर्चा करना है." Should a person visit the police station?
If found any false or if not found any genuinity, then ask him to send a summons or send the notice.
Yeah. No. I told him that he's saying in the opposite party is not interested.
Hello.
English.
No, so he's saying, "नहीं आप आ जाओ, opposite party is not interested in pursuing the matter, but I want to understand the case." If the opposite party is not interested in pursuing the matter, what does he want to understand?
It means that you want to settle the matter or you want to something achieve from you. That is intention. Otherwise, there is a no meaning.
I can legally refuse to go.
Yes, definite, sir.
Okay, thank you. Thank you, sir.
Hello.
Ramesh, Ramesh sir.
Yes, please.
Actually, what happened generally in most of the time, police officer has not been taken the FIR in the criminal matter and asked the complainant to file a written complaint. Okay, and he just acknowledged that complaint. So in these circumstances, how we can pressurize the police officer to get the FIR done?
Okay, that is a good question. That we have way. If police officer is not taking your FIR, then you have to approach to the senior police first, SP or DCP in your area. If you are not satisfied with the SP and DCP, then you have to approach to the judicial magistrate under section 156(3) and make a complaint to the judicial magistrate and give a direction from the judicial magistrate to take action in that matter.
Okay,
then you will get a result. Yeah.
So for the SP or DCP, I need to written complaint.
Yes, written complaint.
Okay, written complaint. Okay.
Yeah.
Jadhav sir, this is Mr. Rao once again. A slight small suggestion, if it is okay by you. You are very senior to me, but I just when we discuss 154 and FIR, we have to discuss Lalita Kumari judgment.
Yes.
That is the fundamental Bible. No police officer can refuse an FIR if
Yes.
cognizable offenses are revealed. And this is
Yes. Yes.
happening day in and day out. I am an activist exposing
Okay.
corruption. So I deal with this on a daily basis.
Yes, sir. Definite, sir.
So next time, sir, when you do a session, start with the Lalita Kumari. That is the Bible.
Yes, yes. Definite,
Where,
sir. I will take.
where
I will take.
I'm sorry,
Yes.
this is a suggestion. Don't misunderstand me,
No,
please.
no, no. So it's okay, sir. I will take, sir. That is a good suggestion from you, sir. Thank you so
Yes.
much.
Welcome, sir.
Yes.
Anyone else has any kind of questions?
So, this is Advocate Simran Sheikh.
Yes.
I need to ask one question.
Yes.
Jadhav, sir.
Yes, yes. Please go on.
Good morning, sir.
Good morning, sir. Please go
Sir,
on.
we are one of my client. He is into the business of sale and just hold on, sir.
Yes.
He is into the business of sale of biodiesel products, and the central government has given us a gazette.
Okay.
Implication of the year 2019. But Maharashtra government is refusing to give us any further implications or any guidelines to carry forward with the said business. And one or
Okay.
two of our colleagues, they are also into this business, but they have been arrested for setting up of this biodiesel business, and they are telling that they are not following the norms. Though we have been given the norms from the central government, but the
Yes.
state government is not accepting it. So what should be the next step to carry forward with it, sir?
Yeah. You have a remedy is there. You approach to the High Court because that direction, central government has given a direction. Yes. And gadget is there. Then
Yes.
the state government has to follow. If they are not following,
Yes.
then you have to file a writ petition in the High Court. And
Okay,
get
okay. Thank you so much. We are on those lines only. We have filed the
Yeah,
petition.
that's good. That's good. That's good. Yeah.
Sir, if at all, I need your personal number, sir.
Yes, that you will get it from the organizers.
Okay, okay. Thank you so much, sir. Highly
Yeah.
obliged.
Thank you. Thank you. Thank you. If
Thank
anyone
you.
have?
Anyone else has a questions? Okay, so I have one question.
Yeah, please.
Okay, yes. How to cancel non-bailable warrant in court against the accused without proceeding the accused before the court? If you can just help me with that information.
Yes, yes. That is a Justice Tehelani in Bombay High Court has passed the order that if accused is not present before the court, then court has the power to pass a cancel the warrant.
Okay.
Okay. That order Arun Kumar Chaturvedi versus State of Maharashtra. In that case, entire point has been discussed.
Mhm.
And
All right.
in general, mostly in bailable offense or non-bailable offense, warrant will be issued by the court. And normally, court pass the order and cancel the warrant. Some fine may be imposed, but normally it's happened.
Okay. All right. And what about in which matters basically the anticipatory bail is granted?
Anticipatory bail is granted. That is non-bailable.
Okay.
In non-bailable sections, only non-bailable section anticipatory bail has been granted.
All right. All right. Anybody else has any questions? Please ask.
Yeah. Hello.
Yes. Yes, Mr.
Yeah, I just got one question that what are the right
Sure.
of victims?
Uh-huh.
Yeah, maybe I just wanted to light on that.
Sure. Sure.
What are the right of victims? Right to attend criminal judicial proceeding, then right to appeal, of compensation, right to heard and participate in criminal justice proceeding, right to inform a proceeding, and even in the criminal justice process of legal rights and remedy and of available service, right to protection from intimidation and harassment, right to restitution from the offender, right to prompt return of property, right to speedy trial, right to enforcement of these rights, and constitution right to be treated with fairness, dignity, and respect, be informed of proceeding, and even such a release of the accused, attend trial and other proceeding, be heard on critical point as parole hearing, be awarded restitution from a convicted offender that has that rights got of victims.
Thank you very much. Any further questions any of the participants wants to ask? All right, so thank you very much, Advocate Ramesh Jadhav. You have really shared a very knowledgeable information. I really thank you very much on behalf of Samruddha Bharat Sangh and LEXGENUS. I will request all the participants to please raise your questions further on info@leggenus.in, or you can call us on 937. Yes, please.
एक प्रश्न विचारू शकतो का अजून?
Yes, Swapnil, you can ask.
येस रमेश सर, बऱ्याच वेळा असं होतं की पोलीस ही अटक करते, FIR दाखल होते, सगळं काही होतं, पण नंतर कोर्ट सांगतं की नाही नाही हा म्हणजे अशी केसच नव्हती, सगळं मुद्दाम केलं किंवा चुकीनं घडलं, असं तसं होतं, आणि आरोपी नसतानाही अटक होते, पण नंतर त्याला सोडून दिलं जातं. पण यामध्ये त्या कालावधीपुरतं आरोपीची बदनामी होते किंवा त्याला नाहक समस्यांना सामोरं जावं लागतं. मग अशा वेळी ज्या व्यक्तीला अटक करण्यात आली आहे किंवा त्याच्यावर खोटी कारवाई म्हणता येईल तशी झाली असेल, तर त्याच्याकडे काय ऑप्शन आहेत?
येस 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 देअर इज. जर असं जर झालं असेल तर तुम्ही झाल्यानंतर म्हणजे मॅटर झाल्यानंतर तुम्हाला सोडल्यानंतर यू कॅन अप्रोच टू द हायकोर्ट विथ अ रेट पिटिशन दॅट दी इलिगल अरेस्टमेंट, इलिगल अरेस्ट, त्याच्यावर तुम्ही हायकोर्टमध्ये पिटिशन टाकू शकता, रिट टाकू शकता, आणि त्याच्याकडून हायकोर्टकडून तुम्ही डायरेक्शन्स घेऊ शकता, आणि यू कॅन आस्क द कॉम्पेन्सेशन. that remedy is there.
Okay,
we have to approach to the High Court. Yeah.
Thank you, sir.
Thank you, Swapnil. So as I was saying that you can connect us on 9372886473, and also drop an email to us on info@leggenus.in for any further queries or questions. We will surely address that. And along with this, I also want to request all the participants to get registered on our next session, which is happening on 15th of November. It is a testamentary matters, wills, probate, and succession that will be taken by Advocate Virendra Pratap Shastri. Right. So please register yourself. The link is given in the meeting details on this same page, or else you can register through the LEXGENUS website even. Right. Thank you very much, all the participants. And
thank you so much, sir.
Yeah, thank you very much. So we make sure that we keep meeting on this kind of knowledgeable Sunday mornings. All right. Thank you very much, everybody. Have a great day ahead. Thank you.
Thank you.